Yes.
Yes, if it may please you, I can provide somewhat of an update. I have received information from an official in the ministry dealing with these matters from a gentleman by the name of Mr. Clement Antonio, who advises, and we will be able to provide the court with the necessary documentation and the link, the web link that gives information. But there was, in fact, in 2012, approval by the Cabinet of a sustainable, by Parliament, a sustainable island resource management and zoning plan. In 2012, there was parliamentary approval of a sustainable island resource management and zoning plan. So that deals with the issue of...
Was that something under Section 9 of the 2003 Act, or that sounds like something different?
Well, it speaks to a plan that dealt with the entire country, the island of Antigua, Barbuda, and Redonda, the uninhabited island of Redonda.
Right.
And it dealt with the whole issue about...
Okay, sorry, my question was that a development plan within the meaning of the 2003 Act, Section 9, or was that a plan sort of created by some other means?
I don't have full details, but I can say a plan appears to have been done in consultation with a United Nations agency. But I just want to provide that update, and I will provide fuller details after the hearing. But I just want to provide that update.
Thank you.
My Lord, just very briefly, going back to Section 22, 22.1, the issue of notification under Section 22.1 is that that section provides that the town and country planner is to give notice to the applicant, to give notice to persons who might be affected. So that is what that is limited to. It's not so much that the town and country planner gives notice, but he directs the applicant to give notice to such persons as may be specified in the notice.
That's the point I was making before lunch, yes.
Okay, all right, so I appreciate that. And I also, I think upon reflection, when it comes to subsection 3, I do understand, I think now there is quite a bit of force in what the position seems to be of the board, and perhaps it shows that there is need for consultation to perhaps revise the text of the of that section, so it more aligns with the position that the board may have.
But was a notice given to the developer pursuant to Section 22.1?
I have no information on that. I have no information on that. What I can say, again, this is just based on information received from Mr. Antonio, is that with respect to persons in Barbuda may not having knowledge of a new airport, there was a village council meeting where an economic project was discussed, and as part of this new economic development, there was included as part of this whole project reference to the airport, a new airport. I cannot say, and I don't want to mislead, I cannot say that that consultation strictly complied with any requirement under the Act. But I think it's fair to say that the idea of a new airport did not come like a thief in the night. It was part of a larger economic development project that would have been made known at a council meeting in Barbuda. The present airport in Barbuda is right in or next to the village, and this new airport is to be situated some miles away. My Lord, if I, with your permission, if I may be permitted to move on to what I hope is my knockout point, which is...
Can you just tell us the date of the village council meeting that you mentioned?
I will have to provide that, my Lord, later.
All right.
Yes, thank you very much. Well, thank you for using the short adjournment to obtain that information.
Yes, I was being flooded with calls, my Lord.
And what is the permission that has been given?
They approved the economic project for the...
No, sorry. For the what is the planning permission that's been granted? Is it conditional, unconditional? And if it's conditional, where will we find the conditions?
I am not aware that the conditions have been specified, but there was one occasion, and it is clear from the record, that what I call full-scale approval was granted, and then it seems to be a turning back of the clock in terms of approval.
Well, I just want to know what your case is as to the present position, which is the operative permission, if there is one. Or has the process not been completed yet?
This one. I would have to obtain some information that I don't have the answer.
Well, one might expect you to come to the board knowing what the permission is that's been given for the project that,
which is under challenge.
Which is under challenge.
No, well, we came here, I don't want to give the impression that we came here with the understanding to argue a standing question, because the substantive matter, we have not, as far as the Development Control Authority and the other parties, we have not yet come to the point of putting in a reply.
I appreciate that, but standing to challenge what?
Well, they wanted to challenge the building of the airport by way of getting an injunction. The injunction was, well, in one case was granted and then overturned on appeal. A second application was made for an injunction. The injunction was not granted, and then there came the issue of whether or not the parties had standing. And at that, the matter ended. So
I see that, but if you accept that the question of standing has to be reviewed in all the facts and circumstances of the particular case, then where the defence to the injunction, the basic charge in the injunction was that there was a development being carried out illegally without permission, then your defence to that presumably is, no, there is a valid subsisting permission which entitles the government to do what it's doing. And all that my colleague Lord Leggett is asking is, which is the permission?
Well,
because that's going to be a fact and circumstance in our assessment of standing. What are the circumstances in which the permission was obtained? Has the appellant done all the appellants, have they done all that they could in the circumstances to engage in the planning process? And so I think we do need to know what the government's view is on what is the extant permission. I had assumed from reading the papers that the last permission, the conditional permission, was intended to be the governing one.
Yes, I suspect so, but as tells as what those conditions are.
But where are the conditions, and do they exist?
Yes, I said, my understanding of the record is that there was unconditional approval, and then there was a turning back to approval with conditions. But as I stand on my feet, I cannot say what those conditions are.
Well, if you could provide a written form to the board after the event, yes, whether or not the conditions have been formulated.
Yes, ma'am.
Thank you.
I don't know about it. My lord, the point I would, if I, with your permission, be able to go on to is that at the end of the day, where do we stand in terms of the appellants wanting to quash the decisions to grant, perhaps belatedly, where the planning permission has in fact been granted. The reality is that the airstrip has been built. It is complete. We are not in a position to turn back the hands of time.
Well, you are.
Well, I mean, let us put it this way. We are aware of the cases about points being academic, but if it were to be the case that the appellant were to make out an illegality on the basis that there had been a failure to consult under Section 22(3) of the Planning Act, and therefore the permission itself was ultra vires and illegal, the permission would be a nullity, and the government would have to apply again to give itself permission to create the airport, and the local community would have a distinct interest in the conditions that were attached to the permission, for example, in relation to acoustics, among other things. It seems to me we're obviously at an early stage in this judicial review process, but if you are conceding that there was not statutory consultation, and if we interpret Section 22(3) in the way that my colleagues have been suggesting it should be interpreted, then the planning permission may be ripe to be declared a nullity.
Yes, well,
these are ifs, I appreciate.
Yes. What I'm saying, even if it were to get to that point that what has been done hitherto by the Development Control Authority is a nullity because of failure to follow the statutory provisions, the reality on the ground is that there is an airstrip there.
Yes, but the enforcement authorities would have power to have the airstrip torn up and the land restored as far as it could be to its pristine state. I'm not suggesting for a second this is going to happen, but there is at least a statutory power to enforce planning law.
Yes, my Lord. The planning law should be respected and should be enforced. But what I'm saying is that as a practical reality, is it reasonable to expect, after all that has happened, that we are going to have a situation where we're going to have to try to rip up an airstrip? But
even if I suspect ripping up an airport is an unlikely outcome.
Yes.
But nevertheless, if the permission that has been granted is declared a nullity, then all the appropriate conditions to protect the environment in relation to the operation of the airstrip the drainage of water, the protection of the water supply which may affect the village, all these issues could be properly aired publicly and imposed by conditions.
Yes, well, I guess that could be. What I'm saying is that from what I gather, the position of the appellants, they are opposed to the construction, or were opposed, I suspect still are opposed to the construction of the airstrip. Well, the airstrip has been constructed.
Your case seems to be that because your client half built the airstrip without even applying for permission, and then managed to complete it, therefore the court should just do nothing. It's one of the least attractive submissions I think I've heard in the Privy Council.
No, I would not put it quite like that. I'm just suggesting what is the utility.
Well, the utility I've just put to you, that even if the airstrip remains, there may be a proper examination of what are the appropriate environmental conditions to protect the local community and to protect the flora and fauna of the island.
Well, my Lord, I would not want to suggest that having proper regard for the protection of the flora and fauna is something that all parties should be properly concerned about, including government actors. That certainly is a noble goal. But I was just looking perhaps a little narrowly on what the practical effect, given that the fact that it's an airport on the...
There isn't an airport, is there? We're told that there's a runway, but no airport buildings. So that's fairly material. You're still going to need permission, or to have valid permission, one would think, to complete the airport and to start flying aircraft there.
I misspoke. I'm dealing with the airstrip that is on the ground. And so that is a point that we would wish to make. We draw the court's attention to what we say is the guidance that is given in the Hutchinson case, if I'm pronouncing that correctly. The Hutchinson case, which we have cited an extract at paragraph 17 of our submissions, and we say that in deciding whether or not well, in deciding how the court, this board, should treat with this matter, which we say is academic, those guidelines we say are guidelines that should have a bearing on the court's or the board's deliberation.
Right, but I don't want to prolong this unnecessarily, but you appreciate what's being put to you is that there are real issues which still arise. So it's not academic. This is a citation that says if there are no longer any real issues in the proceedings, then you treat it as academic. What we've been putting to you is that there are still real issues in the proceedings.
Well, they're real legal issues, but apart from that, there's an airstrip on the ground.
Yes, but there may be an airstrip on the ground, but whether it has been constructed in a way that minimises environmental impact is something which one would have expected to have been covered by relatively sophisticated planning conditions, and you can't even tell us if there are any planning conditions, notwithstanding the grant of what is called a conditional permission. And if it be the case that, that the appellant is able to make out in a judicial review that the permission is illegal, then one is going to have to look again at whether that there are appropriate conditions that can protect the community. And theoretically, at least, the appellant could argue that there shouldn't be an airstrip at all. That is certainly, in the eyes of the law, open to him to do once the permission is a nullity.
My Lord, I understand what the board is saying, and I
mean, you say look at the practicalities. Okay, assume that the government will take the view responsibly that the airstrip should remain. There is the practical consideration of the appropriate conditions.
Yes, ma'am.
And that's not academic, is it?
No.
Well, what's left of the academic point?
Well, my Lord, given that there's an airstrip on the ground, appropriate conditions are certainly must attach to its development and or use. I think that is something that we can face.
Right, but I mean, it should have been fixed at the outset. I mean, the challenge is to the permission that's been granted. You can't tell us what the conditions are. So you're holding out the possibility that perhaps conditions could be introduced at some point in the future. Well, that's the subject of the proceedings, whether and what conditions should be introduced.
Absolutely. Yes, if I may, in my limited time, just want to touch very briefly on a point. As I said, understanding the stage of the proceedings. I accept that the proceedings have been ongoing for a number of years now. But having to deal with an injunction where the respondents were not given an opportunity to be heard, and then the matter went on appeal, and the appeal court determining that there was a breach of natural justice, so that the matter went back to the High Court, where at the High Court the appellants renewed their application for an injunction. Upon that renewed application, that application was denied. The appellants appealed, and upon the appeal, the second respondent put in their counter notice on the issue of standing. And so at this junction, the Attorney General's Serenity really hasn't had the opportunity to what I call put his hand up, because the Court of Appeal, having found that there was no standing of sufficient interest on the part of the appellants, struck out the case. And so we could not, the case being tossed out, we could not have raised the point that we are wishing to make now, which is that the Attorney General is not a proper party to to the judicial review proceedings, because there is not on the challenge a decision made by the Attorney General. And I would just, there are two cases.
Before you go there, if I may, who is the applicant for planning permission? It's the government. We've seen the document.
Yes, but...
So the Attorney General is an interested party in these proceedings, because even if he didn't make the decision, the effect, or if the appellant succeeded in annulling the planning permission, is that the government would lose its planning permission.
My Lord, I accept that the government, because this is a public airport, it's not a private airport, the government certainly has an interest in the matter in terms of, but in terms of judicial review, strictly speaking, it's a challenge to a decision made by a public body or governmental official.
But if I were an applicant for planning permission and was successful in getting planning permission, and someone challenged the decision of the planning authority, I would expect the challenger to serve the application on me as an interested party. And in fact, there would be criticism of the judicial review application if the interested party weren't served with the proceedings.
Well, it's a matter of being given notice of the proceedings is to be named as a respondent. But it's just, as I said, it's not a point that we had the opportunity to develop fully in the court below, given how matters turned out.
When you say didn't have a chance to develop fully, am I right in thinking this was a point not raised at first instance?
No.
And not raised actually in the Court of Appeal?
That is correct.
All right.
It's because we didn't have an opportunity to, as I say, lift up our hand, because by the time that opportunity arose, the case had been tossed out. And so...
Well, no, you could have raised it before then, could have raised it as soon as you were served with the proceedings.
Yeah, but at that time, the focus was having the injunction lifted. That was the matter of priority. That was the substantive issue. Injunction had been issued, had been ordered by the court. We had not been heard, and we tackled that first up. And we were able to succeed in both instances, at both tries, at the Court of Appeal. And that's what we did. If it may please the court.
Was the construction of an airport on Barbuda a matter of government policy?
Yes, it had been discussed at the cabinet level, and yes.
Okay.
It was a government policy. And what we say, we don't see, and I think we've made it in a written argument, if that is what has been on the challenge, I mean, a government is entitled to make those kind of policy decisions.
Not suggesting that you're not entitled to make that policy.
Well, that is all I would wish to say.
Thank you.
Thank you.
My lords.
Thank you very much.
No.
I think someone's about to assist you to tell you where to stand, so our microphones pick up what you have to say.
No, I'm not sure. I got so many. Yeah. Can I have the book? Yes.
Yeah, please do.
My lords. I don't want to disturb my friends. My lords,
Mr. Marshall.
grateful, my lords. I too, like my learned friend, Dr. Dorset, have taken instructions during the break, and I have been instructed and to inform the court and to give my undertaking to supply there was a development plan. It was approved by Parliament, of which Barbuda sits as a representative to that Parliament, who is also the chairman of the local council.
Sorry, who's chairman of the local council?
The representative who sits in the Parliament for Barbuda.
So am I right in understanding your answer as indicating that there isn't a development plan prepared pursuant to Section 9 of the 2003 Act, but by some separate mechanism?
By some separate mechanism which would be treated as a development plan within the meaning of Section 9.
But the procedures in Section 9 have not been followed?
But have not been followed.
Right.
And my understanding on Section 22 is that where an application for development is made, it is the obligation of the applicant to serve it on affected persons. However, in cases such as this, where an EIA, environmental impact assessment report, is included, such as an airport, there is a discretion on part of the town and country planner if he deems it appropriate to himself publish a notice in accordance with 22(3).
And do you say that discretion applies in all cases or only to the subsection 2 cases?
That discretion applies only to the subsection 2 cases, but subsection 1 applies in all circumstances.
Well, no, forgive me. Subsection 1 doesn't apply in all circumstances. It only applies where an order designates certain classes of development, and I don't believe there is one.
My understanding, my lord, is that where there are classes of development, whether it's a residential development or commercial development, and this, I believe, would be classed as an infrastructural development, that where the applicant makes an application, if there are persons who are affected by it, that the applicant would be instructed to serve those persons.
Yes, but that would only be if the minister has made an order under Section 22(1). It may well be
The practice.
has, because I fully appreciate we are looking at this at an early stage,
yes.
Not necessarily in terms of time, but in terms of progress of the development. But if you are to support that permission, that submission, I think we would have to see an order which had the effect of imposing on the developer the obligation in Section 22(1).
Yes.
So showing us these designated classes.
I understand that, my lord, but I was going further to say, in this particular circumstance, and one must appreciate that Antigua and Barbuda is somewhat different from the United Kingdom. I believe we have an entire population of somewhere around 80,000 people, and we inhabit about, we have an island mass of 108 square miles. And your lordships will appreciate that that is significantly different from a landmass
Yes.
of United Kingdom and a population of United Kingdom.
That point is clear.
So what I need to make clear to your lordships, that 2 miles is a long way.
Sorry?
2 miles is a long way. And there is no point in Barbuda from another point in Barbuda that perhaps would not be 2 miles or more. or
Is that a point about standing you're making now?
Yes.
yes.
2 miles is too far away from the airport to be affected by it.
Well, my lord, as ironic as that may seem to you, and if your lordship looks at the findings of the Court of Appeal, they found, his lordship, the Court of Appeal found that the appellants did not work, did not reside, and had no connection with the property being developed.
But that's true of a lot of development. Usually the people that object to development are not the owners of the property. They're people that live in the vicinity of the property.
Correct. And this is the point I'm making. They do not work in the vicinity. They do not live in the vicinity.
Well, even though they live 2 miles away and an airport, an airstrip has been constructed.
The only thing, my lord, is that they are resident in Barbuda.
Right, but you've just told us Barbuda is a very small place, so aren't they almost inevitably going to be affected by the development?
Respectfully, my lord, from the perspective of Antigua and Barbuda, they are not.
Are there people living closer? Are there lots of people near where the airstrip is, right there?
No, the airstrip is in the wilderness, as I understand it.
So the effect is that nobody lives close enough to complain about it.
Well, I wouldn't say that, my lord. I wouldn't say that. And our challenge to the appellants is not that they cannot bring an action to challenge the compliance of the authorities to the Physical Planning Act, that by the method that they have chosen to come.
Or were they given the chance to express their objections through the planning process?
My lord, I do not know if they were given the chance to express their objections through the planning process. I gather that they were.
Sorry, were?
They were. I believe that.
Where's that?
Where do you gather that from?
I believe the evidence is that they wrote. If you look at, I think, Mr. Mussington's affidavit.
Well, they wrote trying to find out what on earth was going on.
Yes.
Now,
Your Lordship.
But you can't have it both ways. If you're treating that as an opportunity to engage in the planning process, that correspondence, that pulls the rug under the carpet from the argument that they didn't engage in the planning process. And one accepts that engagement in the planning process may well be a ground on which standing is conferred. So where does the argument take you if you're saying that they did in fact engage in the planning process?
My Lord, our argument and our position, to be clear, is that the applicants, by the chosen method under Part 56(2) of the Civil Procedure Rules, have chosen to come as being personally affected. Now, they have stood before you today, as they have done in the courts below, and they have argued a public interest aspect, which they chose not to bring. You will observe they brought the claim in their own name. And if I can refer your lordships to the large bundle, you will see the application for leave at page 3714, the affidavit of Frank is at page 3780, and the affidavit of Mussington is at 3732. I would ask your lordships to also have in mind the mandatory requirements of the Civil Procedure Rules. And the Civil Procedure Rules in the Eastern Caribbean are substantially different from the United Kingdom. and also Barbados.
I'm sorry, just before we move on from how the appellants were putting their case, don't we have to look at their application for judicial review where they explain these matters, which is at page 3728, paragraphs 12 to 16 we were shown, where they both rely on their own, if you like, personal interests, but also rely on their interests as citizens of Barbuda and the wider public interest that the authorities in Bermuda should comply with the relevant law. All those matters are relied upon.
With respect, my lord, when your lordship looks at the Civil Procedure Rules 56.2, and I believe that is found at page 1712, I want to take your lordships first to 56.2 subparagraph 3, which is the application for leave. And in particular, subparagraph 3.
Sorry, we're on 56?
56.3.
56.3, sorry.
That's on page 1715 of the
I've
bond.
got it, thank you.
And in particular, subparagraph 3H and I. These are mandatory requirements of the application for leave. So if you're personally affected, you must state exactly how you are personally affected. And if you're not personally affected and you're represented an interest or a group, you must state the public interest.
So why haven't the appellants done all those things in the reference I gave you before, page 3728?
Well, my lord, the appellants have, in the court below, confined themselves to the first limb of 56.2.
But I think that's what I was questioning. If you look at their application for judicial review, where they explain their interest, they don't seem to confine themselves in that way at all.
With respect, my lord, it was very. I had difficulty in discerning whether they were coming for themselves personally or alternatively as a public interest.
Well, the answer is both, isn't it?
Yeah.
That's why you couldn't discern whether it was one or the other, because it was both.
Well, no, my lord.
Sorry, answer.
I can be corrected by the appellants, but my recollection is that they unequivocally explained to the court that they confined it themselves to 56.2A.
But if you look at 56.2B through to E, none of them are talking about individuals. They're all talking about bodies or groups. Now, they didn't purport to be bodies or groups. And the only possible one might be F, any other person, reading short, who has a right to be heard in terms of any relevant enactment.
Well, if you speak, my lord, I would not use bodies or groups in the narrow sense that it must be a formed organization. I would say that residents in Barbuda are a group of individuals. Well, and there are provisions for representative action, which they chose not to bring. Now, they brought this action in their own names on behalf of themselves, stating that they were personally affected by the decision to build a runway.
They stated that they were adversely affected, and as to what was meant by the adverse affection, one turns to their pleadings in the judicial review.
And those pleadings, my lord, though they may fit well within the United Kingdom or even Barbados, are outside of the scope of the Eastern Caribbean. And if you are to apply the Waldron principles, then you have to look at a wider scope of a wider public interest.
Well, I mean, I really do not begin to understand your interpretation of the CPR. If you please look at page 1715. 2A talks about a person adversely affected. 2B, a body or group acting on the request of a person, drawing a distinction between a body or group and a person. 2C, a body or group that represents the views of its members. Again, it's a multi-person body. A body or group which can show that it's a matter of public interest and that the group, the body or group possesses expertise. E is not relevant. And then F, any other person or body. So the rule is clearly distinguishing between a body, a multiplicity of persons on the one hand, and a person individually.
Yes, my lord.
So which other head could the applicant possibly have pursued the judicial review under?
My lord, they could have pursued it as a under D.
Any other body or group?
Yes.
But I just pointed out to you that the rule itself distinguishes between a person and a body.
Yes, my
and
lord.
A person isn't a body. So D, they're just a person.
And they weren't claiming.
My point is, my
They
lord,
to be a group.
if my, there is a if you look at page 1099, and I believe this predates the action, which is a letter petition. I will refer to it as a petition dated the February 2018. You see that it actually includes the applicants, or at least one of them.
Yes.
And you will see it includes both of them, and it includes some 42 persons.
But what point are you trying to make on that? When they brought the proceedings, they didn't claim to be representing these persons as such.
Precisely. They purported to represent themselves. And having purported to represent themselves, then it was necessary for them to demonstrate to the court that they were personally affected by the decision. I've been assisted by my friend on page 62, 682.
Thank you.
At line 16 to 21. And this was the representations made by the appellant's counsel. With your permission, may I read from 12, line 12?
Please do.
He makes a comparison in relation to the marine biologists and particular group. And Mr. Marshall says that neither of the applicants, in this case, have purported to represent the group. That is correct, because we say that this is an application under 56(2)(a). And all the applicants have to show is sufficient interest. So the point we make...
What's wrong with that?
Well, in the United Kingdom and in Barbados, absolutely nothing. But in the Eastern Caribbean, and in Antigua in particular, it requires that you show that there is a direct nexus between you and the decision made.
Can you cite Eastern Caribbean jurisprudence to vouch that assumption, given that it's been conceded that the CPR is to be interpreted in a liberal manner?
Well, you have the Francisco Martineau case, as well as the judgment in this matter.
Which case, sorry?
Francisco Martino, I believe it's part of the authorities.
Well, let's have a look at that.
There's also the Stedroy Benjamin case. There are numerous decisions on the matter, my lords.
Well, let's start looking at them then, if they think you've got authority to help you.
If you look at the appellant's case at paragraph 28, he refers to page 1643. And his extract from the Martinez Francois case, which is a 2004 decision of the Court of Appeal, in dealing with Part 56.2 of the rules, then provides very liberal and relaxed rules of standing for application for judicial review. These, as we have seen, relate to the applications for the prerogative orders. Interested groups and bodies are particularly facilitated. There is still a requirement that the person or body should be adversely affected.
That seems to apply. That jurisprudence applies to all the headings in 56.
By the decision. Interestingly, Part 56.2 of the rules confers standing on a body or group that can show that the matter is complained of is of public interest and the body or group possesses expertise in the subject matter of the application. So in the wisdom...
Does that mean that a liberal interpretation of the rules has the effect that the person, rather than a body or group, who shows the matters in the public interest and has expertise, has no standing in the Eastern Caribbean?
No, my lord.
On the contrary, we come back to the point of it.
On the contrary, what it shows is that if you show that you have expertise in the area and you represent a group and the matter is of sufficient public interest, then you come through the gateway of 56.2, I believe it is D or E. But the appellants before you have not chosen to come through that gateway. If they had chosen to come through that gateway, perhaps we would not be here arguing. They have confined themselves to 56.2A.
Well, on the face of it, that looks perfectly good for them. So what is your authority for saying that should not be given a very liberal and relaxed construction?
Well, my lord, even if you give it a liberal instruction, I fail to see that if you don't live in the area, if you don't work in the area, that you are adversely affected simply by an airport being on the same island that you live and work in.
How many miles wide, how many miles is Barbuda? What by what in terms of miles?
I think it's 60-something miles long. 60-something square miles.
Square miles. So what is it?
But I can't tell you the dimension.
6 by 10 or?
What I can tell your lordship is that it is too far for you to walk. It is way too far to walk. The entire length.
If it's 6 by 10 miles, I beg to differ. I think I could manage that.
Well, my lord, I have observed that in the United Kingdom. You walk very far. But it is a different community.
Of course.
And the point that I wish to emphasize and I wish the court to be seized of is that within the context of the society, the development was not taking place in the community of which the appellants worked, lived, or had any activity.
You referring to the Martinez case, you'll see actually quoted at paragraph 29 of the appellant's case, the case of Treasure Bay, St. Lucia, where the same CPR rules are considered by Mr. Justice Ramdani. And he says that the rules of standing are very liberal and relaxed. Rollins J.A. may have actually interpreted the rules in a somewhat narrow manner when he stated that there's still a requirement to show that the applicant has been adversely affected. So he seems to take a slightly different view from that was expressed in the Martinez case.
I believe one was a High Court judge.
Yes.
And one was a Court of Appeal.
Absolutely.
Yes, but in the Treasure Bay case, the point that Mr. Justice Ramdani is making is that 56.1 is the test. 56.2 talks about categories which are included within it and may not be exclusive of the categorization. It seems to me that if you are taking a broad and liberal and relaxed approach to standing, as Justice of Appeal Rawlins said, then one would start with the general category in the first subparagraph of the rule, and then look to see examples of such a sufficient interest in what follows, without necessarily saying those are the only categories to which the concept or the criterion of sufficient interest would apply.
And that is a point very well taken, my lord, but I must return to the position that that's not what the applicants did. The applicants before you, the appellants before you, have elected to confine themselves to one head.
We're here to decide points of general public importance, and I would have to say that the board is unlikely to decide a matter based on the pleading of 1A rather than 1D. Well, the question is, in these circumstances, does the applicant, or do the applicants have a sufficient interest under CPR 56.1? And my colleague, Lord Sales, has referred you to what they say in the judicial review proceedings as the grounds on which they are pursuing their claim.
I understood, my lord. I can only say that the applicants themselves have stated that they...
Well, I have that point, yes.
They have confined themselves to 56.2, 2A.
Yeah.
And...
if I might add, there's the point that my Lord Hodge makes, that the basic test is in 56.21, and one would think that a liberal construction of the rules actually invited main focus on that. But even if one's looking at 56.2a, there's a question about what does adversely affected mean, and if you adopt a liberal interpretation of that, it might be said that the appellants are well within that rule as well.
Yes, well, you see, the requirements to meet 56 subparagraph 2, subparagraph 2, are set out in the application for leave and must be contained in the affidavit pursuant to 56.2.3. When you look at the affidavits of both Frank and Mussington at the time of the application for leave, those are the affidavits filed on the 6th of July, 2018. They simply just do not muster what is required.
Isn't every citizen of a small island adversely affected by the degradation of the natural environment on that island?
No more than the citizens of the United Kingdom are affected by the degradation of or the non-compliance of legislation. Yes, there are general public interests, but that's not the application which they...
Well, for example, we were shown that the airport is going to use the same water supply as the village of Codrington.
My lord, so far as what water supply the airport is going to use and what's going to happen in terms of the development of the airport, I think we're at early stages. There are a lot of allegations. There is also,
this was just something in the report, I think, prepared under the supervision of your client, identifying that this is a problem with the environmental impact.
My client is the airport authority. I don't think they supervised any reports.
No,
sorry.
It's the first and third respondents.
Yes, the third respondent, yeah.
But what I will say is that the I think there is an affidavit of the head of the environmental department, which I invite your lordships to have a look at, because it sets out chronologically what happened. That is the affidavit of Diane Blacklane. It's at pages 1031 to 1037. She refers to a number of exhibits in the affidavit, and unfortunately, those were not included in the record. But this was an affidavit, I believe, that the first respondent used in the injunctive proceedings. I'm not aware that it has been controverted, but we're not at the stage where you would controvert it. But certainly it paints a completely different picture.
Which parts are you focusing on?
Hold on. I have it. No. M35. Yes, I begin at paragraph, if your lordship's attention could be drawn to paragraphs 17 through to 22.
Can you just help us with the page number for that?
1035.
Thank you.
The actual affidavit begins at 1031, but I'm directing your lordships to paragraph 17 at 1035. Would your lordships care for my assistance?
No, we can read it perfectly well, thank you.
What am I doing with time?
So there's a dispute about the amount of environmental damage being caused. It's accepted that some damage is being caused, but apparently not out of the ordinary.
Apparently,
whatever the ordinary counts.
Apparently, it's impossible to make an omelette unless you crack the egg.
Of course, but one can build a hotel, and unless the tourists are unruly, there's only a certain amount of noise. One can build an airport, and whatever happens, there's going to be a lot of noise. I think one of the criticisms made of the EIA is there was no acoustic assessment. Is that right?
I'm not in a position to say that it is right.
But you ought to know, because should you not? I mean, your clients are involved in this. Was there or was there not an acoustic assessment in the EIA?
I know that the reports are before the court. I have not read the report cover to cover.
No.
Very voluminous, and I do not know. I would not be able to tell the court now if specifically there was an acoustic assessment done.
Well, if you look at page...
What I will say is that the fact that the horse has bolted, so to speak, and I make no pronouncements on whether the horse has bolted correctly or incorrectly, the horse has bolted, so to speak, doesn't mean that the appellants are without remedy. What I will say is that in these proceedings, irrespective of your lordship's ruling, if you look at the claim form, which is for a mandamus and an injunction, which are prerogative remedies, it seems extremely unlikely, without a completely redrafting of this claim, for the appellants to obtain, for example, if there wasn't an acoustic report done, enforcement of those proceedings. Certainly, there is nothing to prevent the appellants from bringing administrative proceedings.
But why should they? If the planning consent has been obtained unlawfully, why shouldn't they be entitled to complain about that in judicial review? That seems completely standard.
It is not enough that the planning consent, my lord, respect, has been obtained unlawfully in these proceedings. In these proceedings, what they sought was a mandamus. And what they're asking this court to do is to reinstate their claim, which is a claim for mandamus.
But if the court were, if the proceedings were to continue, and if the court were to conclude that the planning permission were a nullity based on the absence of proper consultation, proper notification under section 22(3), would the appellant not be entitled to an injunction against any further development?
Well, with respect, my lord, and I forgot to say, my instructions also are that the airport is scheduled to commence operations later in this month.
But the road has been built?
I have
and
no
the terminal buildings in place?
I have no idea, my lord. I have not been there myself.
Well, then you can't expect us to be operating on some assertion if you've no idea what the facts behind it are.
My understanding is that the airport is scheduled to open.
Well, that makes it rather urgent then.
Indeed.
So that might be a reason for granting mandamus.
Well, my lord, when you look at the claim, which is for mandamus,
Can you just show us where in the bundle we see the actual claim?
Yeah.
Because I don't have that to mind.
I think you'll find the claim on in the first large bundle. I think there are two claims. There's one which was filed on the 6th of July, which is somewhere around 3783, and there was one which was filed in August. I think that's the one that we need to look at.
So 3714 seems to be the application for leave to apply for judicial review, which certainly I had thought, and
yes.
I think Mr. Willer showed us, was the pleading which instigated.
There is a claim form there, but I believe that was a nullity because it was filed prior to the grant of leave. And then there was, but I think if you'll...
So I'm now looking at page 3717, where what is sought is judicial review, and they say they seek an order of mandamus compelling first respondent to use its enforcement powers. So that seems to proceed in two stages. The one is to quash such consent as has been granted, and then seeking mandamus for exercise of the enforcement powers. So the first stage would be a quashing order, wouldn't it? And then the second stage would be a separate claim for a mandamus.
The claim is at page 46.
Page 46.
And the relief sought is at page 47.
So is that I'm now a bit confused. Is that different from the document we've been looking at so far?
Apparently so, yes. The document you've been looking at was filed on the 6th of July, prior to the grant of leave, and would be a nullity.
Well, it looks pretty similar.
Yes.
Sorry, which page are we looking at? I'm so sorry, I'm being slow. 46. 46.
Well, I would begin from page...
Yes, page 46 looks identical to the other,
yeah.
more or
Yes.
less. So what I just put to you would apply to that, wouldn't it? It proceeds in two stages. They want judicial review in relation to what's happened in relation to application of the planning laws, which is to say, quash such permission has been granted. And then secondly, they want mandamus in relation to exercise of the enforcement powers that would then arise. You can only get to the enforcement powers if there isn't a valid planning consent.
Well, yes, my lord, they want certiorari, and that would be in respect, I believe, of permission.
Yes, over the page, in order of certiorari to quash the decision.
They want,
That rather spells out,
Yeah.
I think, what I was saying.
And then up the top there, I see they want it restored to its
And then they want
previous
mandamus.
condition. Well, that's all still relevant.
they want an order of mandamus for compliance with the Physical Planning Act for the construction.
Yeah.
Right.
Well, those are all still highly relevant.
Well, I would respectfully submit, not, my lord.
Well, we're not here to determine the final award of relief.
Well,
We're just here to determine whether they've got standing to ask for it or not.
and if you look at paragraph 1 of the relief sought on page 57, 47, my apologies. What the appellants were concerned with in the claim form was not an airport, but an, what did they say? Airstrip, airport, construction of the airport airstrip on Barbuda.
The airport, in other words.
But anyway, I'm not sure it really matters. I mean, the development thus far has been construction of an airstrip, and they're saying, well, you shouldn't have had consent for that.
And if you've gone on building since and it's now looking more like an airport, well, that's covered as well, actually, in their relief.
Yeah.
And so what you would in fact have, my lord, and I remind the court what is before it, is only the appeal on the cross appeal, not on the injunction.
Forgive me for putting it in this way. So what?
The respondents have not been brought here to answer the question of an injunction.
No, we're certainly not.
Respondents have been brought here only to answer the question of standing.
That's absolutely
Yeah.
right.
Yes.
No one's disputing that, but
You were saying, I think, that it didn't matter, the question of standing, but it looks highly important.
What I'm stating, my lord, is that there now, given the state of the construction, there are alternative remedies, and judicial review would not be an appropriate remedy.
well, I mean, we can't, if notwithstanding these proceedings, your clients and the government have proceeded to build roads and build terminals. That's nothing that we can take into account. All we're making a ruling on is the question of standing. And if I could return to a question I asked you about earlier, can you please at page 3562?
3562.
Yes, which is a commentary by, is it the Department of the Environment on the EIA, and you were saying that you have to break eggs to get an omelette. Indeed you do, but what it says is noise has been identified as one of the most impactful factors in the development of an airstrip, yet no acoustic survey was conducted. The impact of noise on stakeholders was, I think, considered outside the scope of the EIA, and no acoustic survey was conducted. Acoustic survey needs to be conducted to determine the severity and area of impact of the noise. Acoustic survey not conducted as part of the EIA. This needs to be conducted as a matter of urgency. Did your clients conduct an acoustic survey?
I have no instructions on that.
Well, we've got the evidence, haven't we? These are from people that did actually review such EIAs as exist, and they're positively saying there was not one.
There was not one.
But, my lord, if I understand this document,
This is the document from the consultants that were put in place to review such
That's right.
EIAs as had been obtained. So they have certainly seen the EIAs and they're commenting upon them. And they're saying there's a serious defect, no acoustic survey, one should be done as a matter of urgency.
This was, my lord, if I understand this document is dated June of 2018.
No, it talks about
And
the hydrology support report being submitted in July 2018.
And it says site visit on the 28th of November 2017 and 14th of April 2018.
And table 1 is a summary of the department's concerns about the EIA.
Yes, my lord, but as I understand it, these were the concerns as they stood in June of 2018. So to say whether or not there has been a change from this position between then and now, yes, there has been a change. Does it include an acoustic survey? I do not know.
No. But I mean, remind me of the dates when the planning permission was granted.
Your lordship will find the planning permission
In principle, it was in May,
on
and then the development permit in 18th of July, and then a conditional approval on the 10th of September.
well, I think the planning permission is on page 1113.
Sorry, just before we leave this document, I mean, on page 3560, there are references to the revised EIA. So I think they've had both.
Yeah.
As far as I'm aware, there are only 2 EIAs that are being referred to in these proceedings, and they've had both of them.
And on 3554, there's the list of breach of process. Construction commenced prior to application. No Barbuda Council endorsement. EIA presented with significant gaps. Revised EIA persists with significant gaps. No monitoring reports.
I'm
And
sorry,
you've put in
sorry,
no
my lord, I
evidence
didn't
to
get
say
that
that's,
page.
3554.
3554.
As far as we know, nothing's been done to rectify that situation.
Well, I don't know, my lord, because as I said, that was the position as it was in June of 2018.
Well, how are you in a position to submit that this is all academic in that case?
Let's look at the context.
My lord, I didn't say it was academic, please. I
You
did not.
didn't? Okay.
I did not say it was all academic. What I said is that there are alternative remedies available other than judicial review. Judicial review, as I understand it, is limited for those exceptional circumstances and should be used as a last resort. There are administrative remedies.
What are they? What are you suggesting?
They can bring an action, a simple action for a declaration, and I refer your lordships to this court's decision in the Attorney General and Isaac, Giselle Isaac. As I keep reminding the court, the development of administrative law in the Eastern Caribbean is substantially different than in the United Kingdom.
No, we must apply the jurisprudence of the Eastern Caribbean. We fully accept that. But on the question of standing, your jurisprudence suggests that we should take a liberal interpretation of standing.
Yes, but notwithstanding a liberal interpretation, it requires that the person is affected by the decision.
Well, we've been through
And
this.
affected doesn't mean I don't like it,
Well, again,
or it wouldn't be a decision that I would have made.
but again, we were referring you to the document, which I think may be the text of the advisors, but this was sent by the Department of the Environment to the Planning Department in a letter dated 4th October 2018. That's electronic page 3552. And so the inadequacies of the EIA and the revised EIA were those which existed a month after the conditional planning permission was given. And we still don't have any indication of what are the conditions that were imposed in the planning permission, if any. So how can you say, where there is no acoustic survey, that someone living 2 miles away from an airport will not be adversely affected by it?
Blacklin's affidavit. I crave your indulgence just a moment, my lord. Is that 1031? When was her affidavit made? Now, I refer you, Your Lordship, to the affidavit of the head of the Department of Environment, which is Ms. Blacklane. And I hear Your Lordships, and I see the document, which is dated 2018. You will observe that Ms. Blacklane's affidavit is dated 2019.
Could you give me the page number, please?
1031.
Pardon?
1031.
1031, which is dated the following year. And you will see that Ms. Blacklane, in her capacity as the environmentalist, the chief environmental officer, was satisfied.
Well, she doesn't seem to mention the letter of the October 2018 or address any of the concerns raised in that letter. She just seems to ignore it.
Well, at paragraph 12, she indicates quite clearly that in around June 28, an updated EIA was done by BHM.
And we know that didn't cover
directly to develop.
We know that the department itself considered that inadequate and was saying in that letter that they thought a new EIA would be required to cover.
Yes, but the point I'm making is that the inadequacies which he speaks to in June of 2018 are contemporary dated with the document referred to by the court at page, was it 354? At 3554, which is also dated June of 2018.
No, I thought that we'd been through that. I think it's 3554 is part of the report, which is October 2018. And it's compiled by consultants who have most definitely seen both the original EIA and what Ms. Blacklane refers to as the updated EIA. They've seen both of them, and they say they're both defective.
And they write to the planning department to tell them they're both effective. But you might say, well, the horse has bolted here because the planning department has already issued its permission. It's conditional permission.
Yes, my lord, but the report of October 2018 still predates the evidence of the chief environmental officer.
Yes, but where is there any facing up by the chief environmental officer to the advice that she was that her department was giving to the planning department? In paragraph 16, I know the affidavit says these developments are not allowed to proceed without taking great care to protect the environment as much as one can possibly expect. But these are just general words. Where's the evidence to support that? The fact is, this is an airport without an acoustic survey.
And she simply doesn't address the letter setting out a whole list of inadequacies and saying a comprehensive EIA will likely be required. If it's no longer required, then she's got to explain why.
Well, with respect, my lord,
now, we can't solve all these problems because we're here to discuss standing.
we can't.
But these are all matters which suggest that there may have been a failure to comply with the statutory requirements in obtaining this planning permission. And if the board were to conclude that the applicants did what they could to take part in the process, given that there had been a lack of notification, etc., then why should, looking at the liberal and broad interpretation of the rules of standing, why should the courts exclude these applicants from the judicial review? Because it may well be that the planning permission was illegal. and it may well be that they're affected. You're certainly not in a position, absent an acoustic survey saying that the inhabitants of Codrington aren't going to be disturbed, to say that they are not affected.
Well, to answer your Lordship's question, the first thing I will say, my Lord, is that the ends cannot justify any means. There is a specific gateway for public interest, which the legislators have found appropriate.
Referring to bodies and groups?
Yes.
And you say that includes an individual?
No, I say it includes a body and group, and when you look at the evidence which was available to the applicants, they could have done if you want to pursue a public interest, then you must represent a group of persons or a body, and you must possess the requisite skills. You cannot, of your own initiative, and I would imagine there is good sense behind that, because you do not want a plethora of applications on the same matter. So you don't want each one of the 40-something Barbudans who have signed a petition to bring an action. The court doesn't want to be flooded by that, and so they have set a procedure for, in those circumstances of public interest, for judicial review to be accessed.
So someone expert in an area would have to create a body or group in order to access the courts?
Not necessarily have to create, because I'm quite certain there are provisions within the rules that the applicants could have applied to represent other Barbudans and bring the action on behalf of themselves and other Barbudans.
Thank you.
Can you remind me of your client's position? Is your client the developer? What's the role of your client in the proceedings? In the project?
Under the 2006 Airport Authority Act,
right.
All airports must be operated by my client.
So did your client, was it the applicant for the planning permission?
No, the applicant for the planning permission would have been the government, as I understand it.
Yeah.
Either the government of Antigua and Barbuda or their contractor, which was the Bahamas Hot Mix,
right.
BHM. We unfortunately have been included because the operation of an airport is restricted to the ambit of my client.
Well, clearly your client has an interest if you're right that the airport is about to come into operation.
Clearly. Clearly. And what we're saying is that we're not saying, and we do not advocate a stymied of the rights of citizens to bring and challenge public authorities. What we're simply stating is that in this particular case, the applicants chose the wrong avenue. They could have easily have brought themselves within the scope and brought an appropriate application. They chose not to.
What precisely would be the avenue that you would have advocated for the applicant?
They could have brought an action on behalf of themselves and all Barbudans. They could have brought a representative action. And there's nothing in 56(2) to authorize representative actions. Is there something? No, you could under the rules, and I think it's
probably have
19 or 20.
Yeah.
You could under the rules apply for a representative.
Yeah.
Persons who have common interests.
Yes. Okay.
And then they could have brought that application at the same time as the application for leave, and combined both. But unfortunately for them, they confine themselves to their own interests. And the Act, I think, and it is the intention of our courts, to discourage that on public interests applications. Otherwise, you would have the floodgates open.
Well, we didn't look like floodgates here, does it? I mean, it might be a relevant factor. If there'd been some body that was bringing proceedings for judicial review, it might be a relevant factor that in those circumstances, these applicants were unnecessary and didn't in that situation have sufficient interest. But it's relevant, isn't it, that if it's not them, then it's no one.
But my lord, my understanding is that if there is a specific designation for those applications, then it must be brought within those applications. It is not appropriate to bring it in another designation and then say, well, I fit into this as well.
No.
You know, we are, as I recall, a court of pleadings, and we are confined to our pleadings.
Can I ask you, if it's accepted that there should have been a notice under section 22(3), then that notice should have invited comments and representations either in writing or orally on such application. That's 22(3)(b). If there had been such, and if the appellants had made a comment or representation, then it seems clear from 22(4) that the Town and Country Planner should have taken them into account in determining whether or not to grant a permit. Is that not right?
Well, to begin with, my lord, it is not accepted that the appellants were directly affected, so the requirement to serve a notice under 22(1) was not on them, because they were not part of the community in which the development was taking place, or the area in which development was taking place.
That's not what 22(3) says. The Town and Country Planner, and with putting aside the dispute between May and whether or not there's words missing or words to be taken out, publish a notice and affix a copy of the said notice on the land to which the application relates. So let's say that the appellants see this notice and then they make representations as they're entitled to do, as I read it under 22(3). Is the Town and Country Planner not obliged to take these into account under 22(4)? Because that's what it says.
My lord, my lord misunderstands me. I say that they are not personally affected because of my understanding of section 22(1) is that in every application, persons who are affected must be served by the applicant.
Yeah.
In those applications in which an EIA is required, it is a matter of discretion on part of the Town and Country Planner if he makes the public at large. Now, it may well be that in the case of an airport, one should serve the public at large. I cannot speak for or on behalf of the Town and Country Planner.
But if we take the view that one certainly ought to have been published, then it is the case that the appellants would have been entitled to make representations and comments. Is that not right?
Yes, but that would be on behalf of the public interest and not behalf of themselves. And their case is not that they were not served a notice under section 22(3). That has not been their case. That is an argument which has been advanced here for the first time.
But surely if you had a right to be heard and to make comments and you're denied that right, is that not sufficient to say you've been adversely affected by the decision?
With respect, I would say no, my lord. The fact that I have a right to be heard and I have not been heard does not of itself mean that I have been adversely affected. It may well mean that I have been adversely affected. I would still need to show in what way I have been adversely affected. However, I would say to your lordship that as a public interest point, the arguments would not be the same.
I think what's being put to you is, wouldn't it be natural to say, if you had an opportunity to have your say in relation to this, and you were denied that opportunity which you should have had, that you're adversely affected simply by the denial of your opportunity to have your say?
And that's how I understood the question, and I still say, my lord, no.
All right.
I'm saying, my lord, that I think it's necessary still for you to show how you have been adversely affected by merely being denied your opportunity to say. When you may have nothing to say, doesn't mean that you've been adversely affected. You may indeed have something to say, and therefore you could be adversely affected. But I remind the court that that is not the application that the applicants made.
And just on your other answer to Lord Boyd, you said that Section 22(4) is only directed to you saying something about the public interest. But why should we read it in that way? You might have a very strong personal interest. You may own the property next door, which is going to be very badly affected, just your property. Surely the representations that you're entitled to make under Section 22(3) would include your personal interest as well as...
No, my lord, my lord misunderstood me. I did not say that.
Ah, okay.
I did not say
so you can make representations about anything, your personal interest, the public interest, is that right?
Yeah.
Okay, thank you.
Yes, yes, of course. You may be personally affected by the development.
Yes,
you may be farming your sheep next door.
Yeah.
And it will personally affect you. But in this particular case, the applicants were not. They weren't farming, they weren't living, they weren't working. They didn't even own land there. I mean, there is not even evidence that they have even been to the site.
Oh, yes.
There is. There was an evidence that a police officer was sent round to tell them not to come back.
Well, apart from that singular occasion.
Yes, well,
And that only relates to Mr. Mussington.
yes, but if someone is told by the police that he's not allowed to go in the site, then I don't think you can criticise him for not returning.
Yes, but you can't be adversely affected by something that has only displaced you since it has happened. You know, I mean, you've got to be in occupation before and then be displaced. And we speak about the public interest. We would accept that had the applicants come by way of public interest, in particular, Mr. Mussington, I cannot see an argument that would, which would undermine his access to judicial review. I cannot say the same for the appellant Frank, who possesses no particular expertise. And my understanding of the provision is that where you don't want a multiplicity of actions and you want actions from persons who can only assist the court.
It's overtime.
I'm not going to hear the response.
The court had some concerns, I understand, about the conditional permission. Wait, what page is this? I understand that there was a letter written by the Chief Environmental Officer dated June 2021. I'm not sure if it's part of the bundle, but I do undertake to bring that to the court's attention.
And what will this letter show?
I think she was addressing the concerns of environmental concerns on the conditions and the...
It will identify what the conditions are, will it?
Yes. Well, if you will submit to the appellant's team and to the court,
I wouldn't presume otherwise.
Were enforced. It is somewhat unusual to impose conditions several years after the grant of a conditional permission.
Well, you would appreciate that, given the pandemic.
Yes, of course.
A lot of things came to a complete standstill.
That's a very good point.
Well, that only occurred 2 years after the events we're talking about.
I beg pardon, my lord?
That only occurred 2 years after the correspondence that we've been looking at and the original conditions.
Right. So in the scheme of things, it is not a very long time.
Yeah, thank you.
The only other point I would wish to make is that I don't know if this court is aware that since July of 2023, the leave requirement has been removed.
Really?
Yes, in its entirety.
So you can go straight to a hearing now.
You file your fixed aid claim form,
Yeah.
and you march away. So I don't think the framers of the rules, which is subsidiary legislation, were seeking to stymie the public from addressing the court, from bringing or holding public authorities accountable. But their approach to access is simply different.
Yes. Well, certainly a liberalisation in terms of not requiring leave at all is a liberalisation. It's not the direction of travel, certainly in the UK, which is making it tougher to raise judicial review.
With respect, my lord, as this court has found in the Jesus Isaac matter, which was a few years ago, yes. We have long had two distinct branches of administrative law. You have judicial review, which had required leave, and you could bring an action for declarations which did not require leave.
Yes, of course.
And that is why I keep saying that even if your lordships were to reinstate this case, there are alternative remedies available to the applicants. In judicial review, as I have always understood it, it's like a constitutional motion. It should be and is a claim of last resort.
Thank you. Thank you very much. Mr. Willers, I don't need to hear, the board does not need to hear you on the question of the academic nature of these proceedings.
I'm grateful, my lord. Can I perhaps just deal with a few points raised by my learned friends? One of them, perhaps just as background, and it's important that your lordships have the full picture. We've been told about development plans, we've not seen them, but we have in the bundle, sorry, what's happened with the, forgive me, we have in the bundle certainly a decision of the government of Antigua and Barbuda, which I think you ought to have sight of, just so that we complete the picture, because it relates to the, forgive me, it relates to the airport itself, or the runway. I'm looking for it now. I think it's so many bundles, and I'm afraid I'm not working from a computer. I apologise, but yes, page 1046 to 1047. That's it. So it runs to 1048. This is a letter from the government of Antigua and Barbuda, written by the Permanent Secretary, dated the 2nd of March 2017, heading New Airport in Barbuda, written to Mr. Smith and Mr. Lewis of the Antigua and Barbuda Airport Authority. And the first paragraph explains what it's about. I write to inform you that the Cabinet of Antigua and Barbuda held a meeting on Wednesday, the 8th of February 2017, and noted and approved decision number 89 regarding the aforementioned matter, New Airport in Barbuda. The following is quoted from the original Cabinet decision, 89. Cabinet noted and approved the following submission by the Ministry of Civil Aviation as guideline to be adopted for the construction of a new airport in Barbuda. So there was a Cabinet decision noting and approving the following submission as a guideline to be adopted for the construction of a new airport in Barbuda, and then one can see the heading, subheading, conditional precedent. The site must be chosen. And then there's a reference to the general location, the size of the site, and so forth. You'll see over the page 1047, paragraph 2, the laws of Antigua and Barbuda demand that an environmental impact assessment, EIA, be done for a new airport. And then there is a suggestion that the Environment Division of the government be instructed to have this done as soon as the site is demarcated. And then there are other elements of information that is required. One can see under the subheading B, the length of the runway, the reference to the B757 at paragraph 1. That's a C4 category type of aircraft that it's envisaged might fly into Barbuda, with the reference to, or the suggestion that such an aircraft could be chartered to bring about 100 persons. So that's the sort of aircraft that is in contemplation. So to complete the picture, although I've not seen and I can't take you to a development plan, this appears to be a decision of the Cabinet approving a guideline as to the construction of a new airport in Barbuda, but without any location identified and as detailed as I've taken you in those pages.
So far as one can tell, this seems to be a prelude to the operation of the planning regime, whether by means of a development plan, which would have its own processes of consultation. This has been arrived at without public consultation, or in relation to an individual planning consent, which also has its own processes of publicity and so on that we've examined.
My Lord, yes, I don't know whether or not this decision was in any way publicised, but it may be that the information that is going to be provided by my learned friend will indicate how and when and if it ever was. I also wanted to make a point which comes by way of instructions, but on, as it were, on the hoof, having heard my learned friends talk of the consultation process, I think it was suggested that the MP for Barbuda is the chairman of the Barbuda Council. Those instructing me, and indeed my clients, indicate that is not the case, but maybe that will be clarified when we come to a receipt of that additional information. My Lords, there was reference to a case of Friend. I don't know if you remember that being referred to by my learned friend, Mr. Dorset, I think it was, page 2541 to 2543.
This is the case about the renovation of a cottage.
It is, my Lord, yes.
And the applicant said he lived nearby and he walked up and down the bridleway nearby.
And he was very concerned about the enforcement action taken, but not. But the owner of the cottage hadn't taken the trouble of, or been so concerned as to appeal against the enforcement notice or challenge the enforcement procedure. And perhaps you might think, not surprising then, that the court gave Mr. Friend on a permission application, unrenewed I think it was, but permission application, rather short shrift in terms of standing.
But it's somewhat different from an airport.
It is, my Lord, in scale and in context. The other point that perhaps I ought to address is the way in which the courts in the East Caribbean have interpreted Part 56.2. And we, in fact, my learned friends took you to our written case because we set out in paragraphs 28 to 30 what has been said about Part 56.2. And I think it was my Lord Boyd, but I may have misrecollected, but who touched on what I was hoping Mr. Marshall would have taken you to, paragraph 29 in the Treasure Bay case, where I think it's Mr. Forgive me if I'm wrong, Mr. Justice Ramdani interpreted the judgment of the Judge of Appeal, Judge Rawlings. The page reference for the paragraphs that I'm referring to in our written case, page 1643, my Lords. Paragraphs 28, 29, and then over the page to paragraph 30. And having noted in the Francois case that the Judge of Appeal, Judge Rawlings, had accepted that the rules, Part 56.2, provide very liberal and relaxed rules of standing for application for judicial review, you'll see that in that quote, he said there is still a requirement that the person or body should be adversely affected by the decision, and then referred to Part 56(2)(d), and your Lordships have discussed with my learned friends, particularly Mr. Marshall, the question of standing being conferred on a body or a group. And yes, Part 56(2)(d) of the rule confers standing on such a body or a group, doesn't say anything about individuals. And then when we come to the quote from the Treasure Bay case and Mr. Justice Radamani's commentary on the Francois case, one can see he's referring to it 3 lines down from the top of the quote, at the bottom of the page. I am of the view, he said, that even in saying in Francois that the rules relating to standing are very liberal and relaxed, the Judge of Appeal Rawlins may have actually interpreted the rules in a somewhat narrow manner when he stated that there is still a requirement to show that the applicant had been adversely affected. I think it should be referring to 56.2, but the rule that he referred to is not an exhaustive rule, but merely sets out different categories of claimants who may be regarded as possessing the requisite standing. And goes on to say that the authorities actually show in certain types of cases, even where an applicant may not be adversely affected in the normal sense, he may still be regarded as possessing standing, and that really rather reflects the approach taken by the Supreme Court in the Wharton case. My Lord, then there is a reference to the Young case, and I did take you to this in my submission, so perhaps I don't need to repeat it, but you'll see that...
Just before we go there, yes. you quote in your written case what Mr. Justice Ramdani says in paragraph 73. He goes on in paragraph 74 at 3265 to quote from Halsbury's Laws, where it said that you have regard to all the circumstances of the case, including broader concerns such as the merits of the challenge, the importance of enforcing the law, the importance of the issue raised, the presence or absence of any other person with sufficient interest, the nature of the unlawful conduct alleged, and the role of the claimant in relation to the issues under consideration. So this is East Caribbean jurisprudence aligning itself to Halsbury's Laws.
My Lord, yes, and it goes further than that, because in this very case, my learned friends have aligned themselves to the criteria laid down by Lady Justice, Chief Justice Keegan in the Duff case.
And they also agreed, or at least with the list of criteria, similar list to the one my Lord read out in the Dumas case in Trinidad and Tobago.
Exactly, my Lord. And so it makes it, I would venture to suggest, incredibly difficult for my learned friends to defend the East Caribbean Court of Appeal's decision in this particular case. But I'm not going to necessarily traverse that ground again, unless your Lordships would like me to do so. You have our reply and all the comments we make in that regarding my learned friend's argument that this case is academic, and I leave that with your Lordships, but whether your Lordships need to trouble with the submissions that we make in that document is another matter, given your Lordship's indication in this case. Perhaps I can just finish by quoting a former president of this very court, my Lord. Page 2489, there's at the top of the page, and this is a case, the very case that my Lord Legate referred to a moment ago, the Dumas case, begins at 2488, and it begins with a quote from Baroness Hale, "Who guards the guardians?" Your Lordships may well be familiar with it, but perhaps I can be allowed to read it for the record. "Allowing," says Baroness Hale, "even encouraging people to take an active part in the enforcement of the law, so as to encourage a judge over the shoulder attitude on the part of government, must be a good thing. On the other hand, allowing any old busybody to bring proceedings which will delay or even prevent perfectly lawful governmental actions and decisions must be a bad thing, as must allowing them to interfere in other people's proceedings. Distinguishing between busybodies and champions is almost as difficult as distinguishing between terrorists and freedom fighters. But too close a concentration on the particular interest which the claimant may be pursuing risks losing sight of what this is all about. Fundamentally, as Mark Elliott has said, the issue is not about individual rights, but about public wrongs. There are better ways of nipping unmeritorious claims in the bud than too restrictive an approach to standing. And I would commend those words to your lordships and invite your lordships, on the basis of that, all that we've submitted in our written submissions and my oral submissions today, to allow.
Can I just be absolutely clear what you would be asking us to do, insofar as we were with you?
Sorry, my lord. I expected.
That's not self-explanatory.
There'll be no injunction.
We're not going back to the decision at first instance. You're not asking us to do that and to maintain the interim injunction, as I understand it.
We haven't.
You haven't appealed that?
No.
No, we haven't appealed the.
So the effect of our decision, if it were to be in your favour, would be to allow the applicants to proceed with their judicial review.
Exactly, my lord.
That and no more.
That and no more, my lord.
I mean, to that extent, we would be restoring the judgment at first instance because the judge did give you leave to proceed. So
Yes, yeah.
I thought you had told us.
Yes.
Forgive me. At first instance, there was an interim injunction.
Yeah, I'm just talking about leave for judicial review now.
Leave for judicial review, yes, certainly.
So, sorry, I thought you had told us the judge at first instance did give you leave.
Yes, granted leave. Initially granted an injunction.
Yeah.
That was then set aside. Then the second application for the injunction was refused.
Yeah.
We appealed that. The counter-appeal on standing came in, and that's what the East Caribbean Court of Appeal were dealing with. So if this appeal is allowed, then my understanding or my suggestion would be that the case goes back to the point it was at, running through to presumably a case management hearing, which would set down a day for the trial and direction.
Yeah, I mean, I think what you're saying is we should allow the appeal, if you're right, in relation to the question of leave, grant of leave for judicial review.
Yes.
But nothing else. If we allow the appeal to that extent, we don't need to do anything more because it'll revert to the order made by the judge in that respect.
Exactly, my lord, yes. And apologies if I didn't explain myself as clearly as perhaps I should have done. Can I just ask one other, make one other request? Is it possible for the court to give some directions as to the timing of any further provision of documents by the...
Yes, we would wish to have the documents for which request has been made within 14 days.
Thank you, my lord. And is it possible, should the need arise, and I'm hoping it won't, for the appellant to have perhaps 7 days thereafter to make any submissions on those documents?
Yes.
Thank you very much, my lord.
Thank you very much.
Thank you.
Well, the board is very grateful to counsel for presenting the parties' positions in this matter, which I can see has been a matter of considerable interest to the public behind you. The decision that we come to will simply be on a matter of standing and the scope of the judicial review. It will express no views whatever on the merits or otherwise of the airport development. Beyond that, I cannot say much other than to thank those who assisted counsel in the preparation of their submissions and in helping them to answer the many questions that we have fired in counsel's direction today. The board will take time to consider what advice they will humbly tender to His Majesty.